I did not. Something like Special Immigrant Juvenile Status, which often, well, always they're going to be minors, but sometimes very, very young individuals, and then also ones who may have a bit of a traumatic history. And so how do you cater the way you communicate and what you communicate them to keep those things in mind? All right. So, and I just, all right. I want to make sure I have this up. Okay, so quick overview of National Immigrant Justice Center. We are a subsidiary of the larger Heartland Alliance, and we are a immigration legal services organization. We have a staff of over 100 individuals working on various legal projects. About half of those are attorneys, and then the other half would be paralegals or additional support staff. This is over 5 different offices, primarily based out of Chicago, but now with offices in Northern Indiana and Indianapolis, as well as offices in DC, San Diego, and El Paso. And, you know, we are a human rights organization. Our goal is to defend the human rights of immigrants, both on an individual level and a larger systemic level. And so in order to do that, in order to meet those goals, we kind of look at these 3 separate pillars, but very much connected and related pillars that we find to be you know, the best way to serve those ends of justice for immigrants, and then also to create sustainable change in these systems that we're working in. So the first pillar are those direct legal services. That's, you know, direct representation in front of the immigration court, in front of federal agencies like SIJS, and a number of other matters. So in a given year, you know, across all different forms of relief and all of our different projects, NIJC is able to serve over 13,000 non-citizens or immigrants. That includes refugees, asylum seekers, you know, folks seeking all different types of relief. And the reason that we are able to do that is because we rely heavily on our pro bono network. We have a pro bono network of over 2,100 attorneys who we partner with to really take on the majority of the legal work, and where NIJC then can provide technical assistance and support in other ways. We also do a lot of the legal screening and case evaluation before placing those cases. And because we have pro bono attorneys in a number of different states and focusing in a number of different areas, we're really able to have that larger direct impact on individual outcomes because of how that network functions and is set up. The second area that we focus on is with federal litigation. So that would be, you know, impact litigation, class actions, basically trying to get an understanding of where we are seeing laws or policies or practices that violate the rights and human rights of immigrants, whether that's at a local or national level, when it's in removal proceedings or outside, and then organizing and planning to challenge those unjust laws and policies to have a larger impact and better outcome across the board for all immigrants who find themselves in the same situation. And so in the past 4 years, we've been very busy with that type of litigation. There's been a number of you know, executive orders and other policy changes that have really negatively affected immigrants and those in removal proceedings. Did a lot to strip them of due process rights, to narrow the forms of relief that are available to them. And so we really try to, you know, collaborate with other large organizations to act fast and support those types of litigation wherever we can. And then finally is our advocacy and policy team, and they really focus on advocating for reform with Congress and with the White House, trying to think of, you know, the larger federal system, which we all know needs to be changed, and there's a lot of areas that are ripe for change. So advocating what would a new just reformed system look like, and pushing for those policies that will achieve that. So that was NIJC on a larger level, national level, focusing on our work here in Indiana. Like I said, we're split between 2 offices. We have a team up in Goshen, northern Indiana, Elkhart County, which was established around 2014. We currently have 3 attorneys in that office, as well as a DOJ rep and paralegal. Our Indianapolis office is slightly newer, been around since about 2019, which includes myself as a supervising attorney and a paralegal. And in both offices, we kind of work across NIJC programs. So we have work on asylum, on SIJS, we work with DACA, family-based petitions, all types of removal defense cases. So it's really just a variety of different immigration services we provide. And right now, these offices, like we said, haven't been around terribly long, but we are currently representing over 600 Hoosier immigrants in seeking out these various forms of relief. So we are a small but scrappy team. We try to provide still a robust set of services and really meet the needs that we're seeing in northern and central Indiana. And like I mentioned before, a big part of this is the reason we're able to have a larger impact and provide services to more individuals is because we really focus on developing strong pro bono models where we can partner with larger firms or individual private attorneys who have resources that they can dedicate towards pro bono areas of law, even if they're not, an immigration law practitioner, they're not super familiar with it. We provide them with everything that they would need in order to understand the law, navigate the system, best advocate for their client, and in a number of areas that you see all listed up here. And so how this works for anyone out there who is interested or maybe might be interested towards the end of our presentation in exploring taking on a pro bono case, SIJS case or otherwise, this is kind of how the program works. Initially, someone will contact NIJC in searching for legal services in need of an attorney, and we will meet with them. We will do a very in-depth case screening, review documents, kind of get a picture of where they are procedurally, what claims of relief might be available to them, and make some determinations about what we think would be the best pathway to obtaining relief for them. And then if we determine that they have a viable case and we think that it's something that we could handle and be successful with a pro bono attorney or otherwise, we would accept the case, sign a retainer with them, and right then and there, NIJC becomes their representative and begins searching for a pro bono attorney or pro bono team to place the case with. So clients know right from the get-go that there's, we are trying to potentially place them with a pro bono attorney, but in the event that we do not find one to take their case, that NIJC has staff and capacity to handle their case and take it all the way to the end regardless. And so if somewhere along the line, whether that's a few weeks later, months later, a pro bono attorney team accepts the case, they become the primary contact and working directly with the client, but NIJC remains on the case, they remain counsel, and we work directly with that attorney or that attorney team to make sure that they have all the support that they need, all the technical assistance, answering questions, mentoring on the law, reviewing documents or filings if need be, and just making sure everybody feels supported and successful in taking the case forward. And so, why is this all important? I think it's important to step back for a second and think a little bit about what it means to be an immigrant. And you can look up here at this list. There's obviously a lot of different types of status that an immigrant might have, and all of them, I would say, bring with them a certain level of uncertainty, maybe instability, because of the precarious nature of these various status in our system. Someone who comes here and is undocumented, does not have any sort of lawful status, I think they are often thinking about when is it going to be the time when something happens that I encounter immigration or I encounter police and I'm placed in removal proceedings or I'm deported or detained, separated from my family. And so living day to day with that fear and that uncertainty really can have an effect on someone, obviously, and how they move forward and looking forward to future plans. And even as you see, the varying other types of status, deferred action, or maybe temporary visas, even moving up to lawful permanent residency, things like that. All of them still are in jeopardy in some ways. That those statuses they can be lost, and they could still result in someone being removed from the country. And so, really, up until we have someone who naturalizes and becomes a U.S. citizen, they may not be fully protected or safe from being removed. And based on where that person would be removed to, they could be facing some very real fears. And so we want to be able to provide counsel to people and walk them through the system, because there is so much at stake and so much uncertainty that is kind of lingering here with these individuals. I think it's also important to consider how the system functions, and because, like I said, there is this uncertainty and instability that you could be placed in removal proceedings, you could be deported at any time. But even once that happens, these are proceedings that may take years and years, even before the immigration court, for a final decision. So you go from a place of fear and uncertainty into this limbo, which just obviously leaves people very, very unsettled. They could be applying, before the court or before another agency, waiting for a visa petition, and nonetheless, just kind of be endlessly waiting for the system to move forward. Many of you may have heard that there's just a tremendous backlog of cases in the immigration system. Tens of thousands of cases that need to be reviewed, and they all take a lot of time and resources. And so there's very little sometimes that we can do to really move someone's process along faster. And so during all this, right, we have a situation that's filled with fear and uncertainty, prolonged, unsettled feelings, and nonetheless, non-citizens do not have the right to appointed counsel. Immigration proceedings and immigration laws is civil law, and so no counsel is provided by the government, and it doesn't change based on the situations, whether someone is actively being removed from the U.S., whether they're seeking a form of humanitarian relief, such as asylum, whether they are in a detention center or not, whether they are mentally ill or if they are incapacitated, if they're a minor. The government does not pay for any counsel, and there's still just a very real lack of available counsel. We have a tremendous private bar of immigration practitioners in Indiana and across the country, but even if all of those attorneys were always available and everybody could access and hire those attorneys, there would still be more cases than those attorneys could actually handle. And so we see a need for sure to continue to develop low bono, pro bono options for individuals, so they can have someone who's going to help them navigate this system. Because when you look at the immigration court system, we have to remember these are adversarial proceedings. Even though they're civil in nature, the U.S. government is actively seeking to have these individuals removed from the country. And the forms of relief are complex. There's a number of different forms of relief that someone may be eligible for. I think, reviewing all the criteria and determining eligibility can be very difficult. And then even once that's determined, meeting the very high evidentiary standards that are placed on someone when they're in front of the court can be very difficult without guidance, especially when someone is thinking about this from a very personal and high stakes point of view. It can be nerve-wracking to try and navigate that and prepare on your own. And I think one really important point to stress is that when we're thinking about specifically for minors, because we're talking about special immigrant juvenile status today, when we look at the numbers, there's a huge disparity in outcomes when it comes to having counsel and not having counsel. So more than 80% of children who appeared in court without representation The numbers show that they are ordered deported or issued voluntary departure, which is not a deportation order, but nonetheless sent them back to their country of origin. And then with an attorney in court represented, more than half of those children are granted some form of status. So it's a very big difference. And because there's so much on the line in these situations, we want to do everything we can to make sure that counsel is present to reassure and comfort and help these individuals navigate the system, but also to make sure that really all of the various forms of due process that is required is respected, and make sure that none of their rights are violated throughout this process. So with that, kind of that big overview of us and our work, I'm going to pass it over to Lisa, who's going to talk today about the big picture overview of Special Immigrant Juvenile Status. And Lisa, I'll kick it over to you.
All right, Wes, can you hear me? Is my audio coming through okay?
Yes, I'm hearing you fine.
Okay, awesome. I've been having some audio issues, so if anyone, if you cannot hear me, just drop a note in the chat and we'll work on fixing that. And on a related note, as we dig into the substance of SIJ, as questions arise, as you think of things that you want to raise with us or have us clarify, please feel free to drop your question in the chat, and we'll do our best to respond throughout the course of the presentation. And as Wes said, we will also include some Q&A time at the end. And I would be remiss if I didn't, first of all, welcome you all again, and then especially thank Lindsay Scott from Kids Voice and Julie Summers-Newman from COIN for co-hosting and planning this and inviting many of you to join us. I have to say, looking at the RSVP list, it's a little daunting to be presenting before this crowd, because I know there's a lot of SIJ expertise among you. And so I hope that you will share your best practices and experiences as well, so we can increase our collective knowledge. And I know a lot of you encounter immigrant children through the course of your work, even if you're not immigration practitioners. And I know that we have a lot of our colleagues from AILA who are here, who are immigration practitioners, and then also some private attorneys who are family law attorneys who are maybe less familiar with the immigration piece. And so to the extent that we can kind of bridge our divides to the extent they exist and combine our experience, I think we do right by the children who live in Indiana, non-citizen children who are in need of protection in the form of Special Immigrant Juvenile Status. So Wes, if you can pop forward the slide, we will dig right in. So SIJ is one of these ways that children can access protection from deportation. So, and you'll hear us refer to it as SIJ or the Special Immigrant Visa or SIJS. So all of that means the same things. It means this form of status that protects children from deportation and puts them on a path towards more permanent status. So allows them to eventually, once they secure that SIJ, in most instances, they'll be able to move on and ultimately receive their green card, so their lawful permanent residency, which allows them, again, an additional layer of security to remain in the United States, more immigration protection, more benefits, and eventually eligibility to pursue United States citizenship. So it's a huge benefit if we can secure this SIJ status for children who qualify for it. One thing that's really important to note, though, is that for children who achieve SIJ status, it limits their ability in one way, insofar as they're not able to petition for parents in the future. So if you have regularized your status, if you've become a lawful permanent resident and later a citizen by virtue of having received one of these Special Immigrant Juvenile Visas, that does preclude that child from later being able to petition for a parent. And that's something that I think as attorneys needs to be an important part of our client counseling with the children that we represent, because Wes kind of mentioned some various forms of relief that are available to immigrant children. Oftentimes we'll encounter a child who might be eligible for both asylum and SIJ. And there are various reasons why we might counsel or recommend one form of relief over another. But one reason might be, we'll talk about how SIJ requires abandonment, abuse, or neglect by one or both parents. And oftentimes the children we serve have one parent who has been abusive, but one parent with whom they still have a positive, good relationship. And so to the extent the child wants to preserve the option of potentially helping the non-abusive parent petitioning for them, SIJ would preclude that option. So that's just one thing to keep in mind as we continue discussing SIJ. So let's go forward to the next slide and begin to talk about where we find the authority for SIJ. So today we're really honing in on the state court piece, so the state law. So we want to look at how does the state of Indiana define abandonment, abuse, neglect, these requirements that need to be met in order to secure SIJ status. But when we're talking about SIJ as the larger immigration relief, then it's found in the Immigration and Nationality Act. So INA Section 101. So Section 101 of the Immigration and Nationality Act is the definitional section of the INA, and that's where we find this definition of what is a special immigrant juvenile, what is, what are the requirements for establishing eligibility for this visa. And then 245H, when we talk about getting to that adjustment of status stage. So after you've secured this visa, after at the very beginning you've managed the state court piece, and then you moved on to get your visa, and you're later applying for your green card, you're adjusting under this Section 245H adjustment, which carries with it some special provisions that are a little different from the types of adjustments we see for people that have gained status through a family-based process or through asylum or through some other way. The Trafficking Victim Protection Reauthorization Act, which we'll provide a little more detail on in a moment, is the piece of legislation that in 2008 really expanded eligibility for SIJ and really improved it as a protection available to, again, immigrant children who have been abandoned, abused, or neglected, or have experienced other similar harm under state law. And you'll keep hearing as a chorus, abandon, abuse, neglect, or other similar harm under state law as this requirement in order for a case to move forward on SIJ, in order for a child to establish eligibility to receive that protection. So there's then the regulations that put into effect the statute that are located at HCFR, and we'll share this PowerPoint with you, so you'll just have these statutory citations and regulatory citations available to you as you continue in your work. But we can go forward to the next slide and begin to explore a little bit of the background of SIJ. So SIJ was created back in 1990. But at its creation, it was a very good, useful tool and form of protection available to children, but it was rather narrow. In order to qualify for SIJ, children needed to be eligible for long-term foster care, and it was a little bit more of a difficult or maybe less useful form of relief. So come 2008 and the TVPRA passage by Congress, really that SIJ was expanded. So you no longer had to establish that the child was eligible to go into long-term foster care. So you didn't need the state to agree to take custody of the child or to become the guardian of the child or whatever the state-based version is of that. You just needed for the child to be recognized under the laws of the state where the child was residing to meet these definitions of abandonment, abused, or neglect. And that's also in 2008 when SIJ changed to allow for the single parent SIJ that I was referencing earlier. So oftentimes it's very common for us to see a child living with a parent and to have a good and healthy and positive relationship with that parent. But if the other parent abandoned, abused, neglected, or otherwise harmed that child still might be eligible for SIJ. So a common place where you might see this might be in a domestic violence situation or oftentimes we'll see situations where a child has come to the United States as an unaccompanied minor and has reunified with one parent while maybe fleeing harm inflicted by another parent. And those can be viable SIJ cases as long as you can establish that one of the parents has inflicted abandonment, abuse, or neglect on the child. So what's important again, and what we really want to stress today in our conversation is this role of the state courts. You know, we at NIJC, we're super comfortable with the immigration side of things and with going before the federal agencies to request a visa and then provide deportation defense in immigration court. What I think is for immigration practitioners a little less familiar is the state court piece. And I think that's oftentimes where SIJ cases, never even get out of the gate because it's been, in our experience, difficult for immigrant families to identify counsel who feel equipped to go into state court and secure these predicate orders. And the goal of our presentation today is to equip practitioners with the knowledge and hopefully some level of comfort to be able to take on these predicate orders and to potentially incorporate these predicate orders into their existing practice. So we'll talk in a moment about the different vehicles that can be used to secure the predicate order in state court. It's not a standalone order on its own. It's not an SIJ order. It's something that's done in the context of another process that the child is undergoing in state court. And so we'll talk about those different types of vehicles or processes and how those might be, how those types of orders or those processes might include SIJ findings. So let's pop forward to the next slide and talk about, again, and we can just buzz through this one, like who are the actors that we're talking about here? You know, you have the parent and the child. In our case, if you choose to do a predicate order and you want to partner with us to do it, we would be thrilled to work with practitioners who are interested in doing this as a pro bono project and receive, as Wes was describing, you know, this sort of training and ongoing technical support from NIJC. You know, our hope is that we can build a pro bono panel in Indiana. And I know that there's already some attorneys that do this pro bono. We've already had some wonderful experiences with law firms who have jumped in and taken some of these cases. So that's, you know, one piece that we hope to grow. And then there is the state court element, which we'll talk in a moment about how it is that you go into state court and initiate the process of SIJ. And there's that really daunting box at the bottom of the slide that says it may involve foreign entities. And we don't have that there to scare people off. But recognizing that when the parents about whom we're filing these requests or these vehicles or against whom we want to have these findings made, if they're residing abroad, as they often are, then sometimes there is some interaction in terms of figuring out service or figuring out what are our obligations as to that parent who's living abroad. But don't be daunted by that, because again, we can help, we can walk you through that, and that's all manageable. And then USCIS is the entity, so that's United States Citizenship and Immigration Services. That's the agency under the Department of Homeland Security that ultimately adjudicates the SIJ petition. So one really important theme that we want to stress and that we want to help our state court judges understand is that our judges are not being asked to decide immigration eligibility. They're not being asked to decide if a child qualifies for SIJ or if they should be allowed to stay in the United States, or if, you know, country conditions in their homeland are so severe that they should be, you know, granted relief in the United States. That's not the question that's being put before the state court judges. What we're asking the state court judges to do is to do what they always do when they're making a child welfare determination, to look at the facts of the child, to look at, you know, who's caring for the child and what needs the child presents and where the child is going to be best served in terms of where they live, where they go to school, who their caretaker is, what their custody arrangement is. These things that state court judges have expertise in, that's what we're asking them to do when they're making an SIJ, when they're making findings that we will use to go before the Federal Immigration Agency and pursue an SIJ visa. So we can go forward to the next slide. And again, there's just this three-step process. There's a state court order, and then there's the petition before USCIS, and then ultimately there's this application for the green card. And we can go to the next slide, and we'll talk a little bit more about the timing of these things. But before we do, here is that definitional section in the Immigration and Nationality Act that I was referencing. So INA Section 101A27J sets forth the requirements for SIJ. You have to be under the age of 21. So when you're encountering children in your practice, or when we're accepting cases, we're looking at the age of the child. Usually, in order to secure a state court predicate order, the child has to be under the age of 18. I know some of you will have experience convincing juvenile court judges or judges that oversee or have jurisdiction over juveniles, convincing them to extend jurisdiction beyond the age of 18. Typically, we want that to happen before the age of 18, if at all possible. But from the federal immigration side, if the child is under the age of 18 at the time we're filing, we're okay. The child needs to be unmarried and present in the United States. And then here's where the predicate order comes in. A juvenile court, so a court that has jurisdiction over the child, has declared that the child is a dependent on the court or placed them under the custody of a state agency or an individual or an entity. So this is, again, where that expanded definition of SIJ that came about in 2008 to the TVPRA no longer says that you need to be in state custody in order to qualify for SIJ. You can be living with a parent, you can be living with a guardian, you can be living with somebody, you can be living outside of state custody and still be found eligible for SIJ. You just need a court to have acknowledged that custody arrangement. And then the state court needs to determine that reunification with one or both parents. So again, here's the single parent SIJ component. You just have to establish that reunification with one of the parents is not viable due to abuse, neglect, abandonment, or similar basis under state law. And then the judge needs to find that it is not in the child's best interest to return to the home country. And this is where judges sometimes get really tripped up because they feel like we're asking them to, conduct an analysis of what are country conditions like in Guatemala, or can this child go back to Mexico? And really, again, we always just want to go back to the fundamentals of making those child welfare determinations, that we're asking the judge to decide whether or not is this child best served staying in the home where the child has been living, being cared for by the parent that is caring for that child, attending the school, having access to the resources that are available locally. So we're not asking judges to conduct a big investigation into conditions in the home country, but rather to do the things that they would do in any potentially custody determination or guardianship or other situation where they're looking at where is the best place for this child, where is this child thriving, and taking those factors into account when they're making this determination. And then the final statutory requirement is that the Secretary of Homeland Security consents to the grant of SIJ status. And typically all that means is that USCIS in their adjudication, after they've got this predicate order, that DHS is ultimately, so Department of Homeland Security is ultimately approving this case. So there's not some component at the state court level or at the predicate order stage where you have to go and ask for some kind of preliminary consent from the Department of Homeland Security or from a federal agency before you can proceed. So let's move on to the next slide and talk about some of these different vehicles that might work where you may raise a case in which you could incorporate the sorts of findings that are required for SIJ. So domestic relations, parentage, or paternity actions are quite common for finding SIJ. Guardianships, if you have an immigrant child who is living with an aunt or an uncle or living with an older sibling or some other trusted adult who's caring for them, it might be appropriate to seek a guardianship in that instance. Adoption, juvenile delinquency is actually my very first, so one of those early slides that Wes showed you, I had forgotten when we put this together, showed a young woman who is now a United States citizen, and she's petitioned for her husband, and she's, got her master's degree in psychology, and she's just really done, this wonderful job building her life and establishing herself in the United States. She initially came to us as a young, undocumented woman who was in juvenile delinquency proceedings, and we began working with her, and the juvenile magistrate who was overseeing her case ultimately incorporated the SIJ findings into his orders with regard to her case, and she was able to then, through the delinquency process, go into to USCIS and apply for SIJ after she had this predicate order that flowed from her experience in the juvenile delinquency system. And I think in Indiana, when we've done trainings with juvenile magistrates, there's been a really high level of interest and openness and willingness and actually eagerness to figure out how they can be involved and support these processes, which help these kids who are sometimes in, a troubled state, or, they've experienced family violence that's resulted in them being in the delinquency system. We've found that a lot of the people that are working with children who are in that situation are often pretty eager to work with us to figure out, well, how do we stabilize this child? How do we, move this child towards being eligible for employment authorization and a driver's license? And how do we make sure that, they're not stressed out about being deported, and so they can finish high school and they can, move forward with their lives? And so again, I feel like in Indiana, we've come pretty far in, working with various state entities and judges and magistrates to familiarize them with SIJ. There's certainly still work to do and space for us to continue that education component. But, I would suggest that we need not, as attorneys, feel super daunted when we go into state court, because I think you'll find that a lot of judges, particularly judges that have jurisdiction over juveniles, I think really are, in most instances, very committed to figuring out what is best for this child. How can, we move this child towards stability? So juvenile court doesn't just mean, the juvenile justice system or kids, it's any judge that has jurisdiction over a juvenile. So again, that's a pretty broad range of judges that would have jurisdiction over these types of matters. So Wes, we can hop forward. And the timeline, I guess this is another thing to be aware of, as you're stepping into one of these cases. Usually we're seeking to obtain this predicate order before the child is 18. The state court process takes, usually a matter of months, sometimes less. We've seen them happen. We've seen some Indiana state court, some attorneys go into state court and really essentially work miracles and get a guardianship in place, mere days before a child is turning 18. And that has given rise to a viable predicate order that's led to an SIJ petition. SIJ right now is taking longer to approve than we'd like. I think typically it's supposed to take about 6 months. The agency is sometimes taking longer than that. When you get to the green card stage, that's where we kind of run into these huge immigration systemic backlogs, where once you've got that SIJ petition, that's kind of your ticket to ride. That gets you in line to get your green card, and you get what's called a priority date, where you're then waiting until your priority date is current, until you get to the front of the line and you can apply for your green card. And it can take, up to 5 years for that priority date to get current. And so that's actually a really tenuous period of time, because when you have that SIJ status, you typically don't have access to employment authorization. You're not in a position where you can do much with your status other than have this limited protection against deportation. And so there's a lot of advocacy happening around hopefully reducing the wait times for people who receive SIJ to move forward and get their green cards. And in fact, the draft legislation that the Biden administration sent over to Congress is just a little bit mysterious. We haven't seen all of it, but it seems to contain a provision that would lift the cap on visas available to people waiting for their green cards by virtue of SIJ status. All right, let's go forward to the next one. And I want to take a moment, and I think there are some questions coming in, so we will shift over to that in a moment, unless Hillary or Ellen, you want to jump in. But why don't we quick go through the 3 Indiana Court of Appeals cases that do some really wonderful things to kind of carve out recognition of SIJ in Indiana, and then we can pause and hit on some of these questions and shift over to Hillary, who's going to give us the real deep dive into how it is you go about putting together these predicate orders. But since 2018 in Indiana, we've had recognition of SIJ affirmed and then reaffirmed and then reaffirmed for our state court judges. So this gives us a really nice foundation to take to state court judges who maybe are not familiar with what it is that we're asking them to do in the context of SIJ. And I'll say again that when we have brought SIJ cases in Lake County, White County, Elkhart, kind of throughout the state, Marion County as well, occasionally we encounter resistance, and I know some of you that are on this meeting have run into challenges in state court, and there have been some judges that have been really resistant. I would say by and large, most judges have been pretty open to considering SIJ and to issuing these predicate orders. And I think when our strategy is to go in and be pretty honest and clear about what we're doing, but also ready to make the arguments about why these vehicles, these guardianships are necessary, these paternity actions are necessary, not just for the immigration purposes, but because these children that we're representing are in need of these state court protections, in order to protect their rights. And by virtue of that, they are also accessing eligibility for immigration relief. I think bringing that candor towards the tribunal and helping judges understand why we're doing what we're doing, why we're there, what this immigration attorney is doing in a state courtroom, I think typically they've been pretty open. I had a judge from White County, get my, the documents that I'd filed, and I hadn't really spent much time in state court before. It's a place that's I always kind of have to go back and read the statute and figure out what I'm supposed to do and call the clerk and figure it all out. But I filed my motions to the court. The judge picked up the phone and he's like, "Okay, help me understand what it is you're trying to do here." And we had a really good and productive conversation, and he ended up issuing the order on behalf of in that case, it was 3 siblings who had been abused by their father. They're living here with their mother seeking asylum. And he issued the order, and then 6 months later, SIJS changed their requirements, and now they wanted us to list these exact state court statutory citations in the orders. And so we went back and had to amend the order, and the judge again was like, now why are you back in my courtroom? But really, I think if we do the work of educating our judges and being very like clear and honest about what we're doing and why we're there, I think that goes a long way towards furthering our cause and hopefully paving the way for other attorneys and other immigrant children that are pursuing that protection there. So, yeah.
Could I jump in here? Because I think educating judges is a really important point, and I just wanted to quickly address one of the questions that came up because I think it's relevant to what we're asking the judges to do. So the question was about a list of people who can testify as to the conditions in particular countries, to be witnesses as to those conditions. And I want to point out here, it's really important when we're explaining to the judges, and I'll go into this when I talk a little bit more about the state court orders. It's really important to explain to the judges, again, the limitations on what they're being asked to do. Like, these are not asylum cases, and we want to make sure we're clarifying as much as possible to the judges. This is not about the general conditions in a country that this child may be from. This judge has the authority and the responsibility to make a best interest determination as to this individual child. So unless, and I know judges may ask for a whole bunch of things, kind of depending on what they understand and what they don't and what they feel like, but I would push back on any judge that asked me for a country expert witness in an SIJS case, because the testimony that matters in determining the best interest of the child before you is either the testimony of the child themselves, the testimony of the parent or guardian, and if the judge has concerns, they're welcome, as they always are, to appoint perhaps a GAL or do some other sort of investigation. But I would really push back on any sort of request for general country conditions, because they simply aren't relevant to this individualized best interest determination that we're requesting here. The judge is not an expert on the country that the child is from, and we are not asking them to be one.
Yeah, that's exactly right. And I think, again, like this trio of cases, so Avila Luis was the first the first decision issued by the Indiana Court of Appeals that said, like, hey, judges, what you're being asked to do is to just make these requisite findings. And Avila Luis is very clear that you don't have to find in favor of the child, but when an attorney is coming before you and asking you to make determinations one way or the other on these SIJ components, you have to engage with them and make a decision one way or the other. And then if we move forward to the next slide, there was the second Avila Luis case that came out in 2019, where that same case bounced back and forth. I think the judge, just was really unsure and really felt, why on earth am I being tasked with making this immigration determination? That's the job of the federal government. That's not my job as a state court judge. And the Indiana Court of Appeals said, absolutely, it's not your job to make the immigration law determination, but it is your job to make these determinations regarding the best interest of the child. And you are only being asked to do what you have the expertise to do, what you do every day in every case. It looks a little different, the language is a little different, but the SIJ determination and kind of the money quote is here is no different from any other best interest determination and should be based on the totality of the circumstances. So then the third case, Bonilla, that came out after that, just again, like affirmed Avila Luis. And this was a case, if I'm remembering correctly, that Hillary was very involved in, and pro bono attorneys from Sigrid Baker Daniels took this case up to the Court of Appeals. And again, just reiterated to judges that their only job in this context, in the SIJ context, is to make determinations on the, as to the facts that are before them, which is what Hillary was explaining. So we've got these decisions in your materials. And I would provide them to a judge, particularly if you have a judge who's not familiar with SIJ. You can say, look, like, we're not blazing new ground here. The Court of Appeals has already looked at this. They have already determined that it is entirely appropriate for you to engage with these requests in the context of, the proceedings before you, and make these determinations one way or the other as to the children based on the individualized facts of the case and your expertise determining, best interest of the child. So with that, I think we'll shift over to Wes, if you hop over to the next slide. We'll get into the details of actually putting together a predicate order in Indiana State Court. And I will kick it over to Hillary with that, and we'll keep an eye on the chat for questions that you may have as we proceed.
Well, thanks, Lisa. Thanks to everyone for joining us again. I'm looking to see a best way to do this. I wish I could see you all. From my last review of the list of attendees, it seems like there's a lot of folks with some experience in either immigration or in family courts in Indiana. But I really do want to encourage you as I'm going through this section to type in your questions as they come up if you have them, because I think some of the things we talk about in terms of going through the state court process I think they're just helpful kind of to discuss back and forth as much as is allowed by this format. Okay, Wes, could you move the slide forward for me, please? So as Lisa was explaining, the predicate order is step one in a three-step process to get an immigrant child's status in the United States. And the predicate order itself can be obtained in any number of state courts. The court just has to be one that has the authority to make some sort of custody determination over a juvenile. Anybody know what the age of majority is in Indiana? You're welcome to type it in the chat if you want. Wait and see if anybody answers. $18. Yep, that's right. So this is an important age to keep in mind because although SIJS is something that a child can apply for until they're 21, depending on the state that you're working in, this is your cutoff age for obtaining this predicate order, right? We are talking about a court that has authority to make juvenile determinations, custody determinations over juveniles. I believe Indiana may have a similar exception to Illinois, wherein if you've started a custody case before the child turns 18 and there are child support issues or the child is still in high school, there's some limited ability to enter orders past 18 or that are effective, I think, either until the child is 19 or graduates from high school. If I'm wrong about that, I apologize. I am licensed in Illinois, but this is my understanding from speaking with folks who do this Indiana work. Regardless, it is still important to obtain this predicate order before the child turns 18, because we want to make sure there is no question with USCIS that this court has jurisdiction over a juvenile while they are still a juvenile under state law. So we've laid out a little roadmap here for obtaining a predicate order, and most of this process is exactly what you would do if you were filing, for example, a divorce case, a guardianship case, a custody case, a parentage case in a regular family court with no SIJS issues. So first you're going to meet with your client, you're going to draft your petition for whatever the type of relief is. Once you draft it, the next step will be some sort of notification to the other side. In custody and divorce cases, service of process is required. In Illinois, at least for guardianship, formal service of process is not required, but notification, so certified mail to the parents is required. Important to note, and I'll talk about this a little bit more, almost all of our cases that involve SIJS findings are going to be default cases, and that will either be via publication because we don't know where the, for example, an abandoning parent is, or a parent will simply consent to move forward, or they'll just be defaulted. So procedurally, you complete service of process, you wait for the adverse party to be defaulted, you file your motion for a final hearing, you prepare your client's testimony for the final hearing, and we'll go over this in the next slide, but your client here is the petitioning adult, right? Your client is almost never the child. There may be some types of cases in Indiana where the client is the child, but here where you're seeking custody or guardianship, the client is the petitioning adult. And then once your procedural steps are completed, you prove up the case at your final hearing. And that's the hearing at which the judge will enter the final judgment, hopefully containing all of your requested findings for SIJS. You could move to the next slide, please. So An SIJS order is obtained as a result of a case in which the court places the child in custody of a person or finds the child dependent on the court. There's some confusion about this because the statute is written in a confusing way. I've seen a lot of predicate orders that have a specific finding that the child is dependent on the court. That isn't really required. It's either dependency or custody. And again, this is a result of the feds writing a law that has a lot to do with individual state laws that are very different, right? In some states, there is a dependency track, basically, instead of a custody track. In Illinois, for example, dependency is part of the process in child welfare cases, but it's not really usually part of the process in a regular custody case or a private guardianship case. That being said, the most common types of cases are custody or guardianship. So child either lives with the non-harming parent and has been harmed by the abusive or abandoning parent, or the child lives with a non-parent, that would be guardianship, and has been harmed by the parents. But it can also include, for example, if there's an order of protection that includes a custody finding, adoptions, juvenile dependency, and juvenile delinquency cases. That's fun, right? Because the juvenile delinquency court actually makes a custody determination as to a child. If they sentence that child to a certain term, that's a sufficient custody determination for SIJS purposes. And as we know, many kids who end up in delinquency situations are there as a result of parental abuse or neglect. So it's something to keep in mind. Finally, the custody order that we enter has to be final. So again, at least in Illinois, in which I am licensed, there's often a temporary custody order entered at the beginning of, for example, a contested custody case. Usually these cases will not be contested. Having a contested case is going to be a very big challenge to getting that non-reunification finding required for SIJS. But B, that temporary custody order, like for the duration of the proceedings, isn't going to be sufficient. It does have to be as a result of a final judgment. Any questions so far? I'm going to keep an eye on this chat box. Nothing so far. Can you advance the slide, please? Okay, so I briefly went over this, just thinking about the types of cases that you would file. As I mentioned, if the child lives with one of their parents and it's the other parent that has harmed them, kind of depending on the marital status of the parent or what's going on, you might file a paternity case for unmarried parents, a divorce case for married parents, and if the parent wants to get a divorce, child support cases that include custody findings can be sufficient for an SIJS order. And again, typically if the child is living with a non-parent, the type of case would be a guardianship. And then finally, if the child is in foster care or under the jurisdiction of the juvenile delinquency court, Indiana has the CHINS proceedings or the delinquency proceedings. So again, your first step is you want to meet with your client. Your client is the adult in this case. You may want to meet with the child, especially if the child is a bit older. In the case of a very young child, we're going to talk a little bit about processes for meeting with clients remotely. But regardless, you will need to meet with the child separately if you do so, right? That's one of the sort of basic principles that NIJC maintains for all of our child clients, right? Respecting that child's individuality, but also respecting that child's confidentiality and really just the discomfort involved in meeting with lawyers in a case involving abuse or neglect. If you do end up talking to the child separately for any particular reason, make sure they understand that they're able to speak with you in confidence, that they can trust you. It's important to explain your role in the case. It's important to explain that you are representing the petitioning parent or guardian, right? And if it does turn out that you get information upon interviewing a child that could give rise to a conflict, that is a case that you would want to send back to us anyway if we have placed this case with you as a pro bono, or it is something that you would want to work out ahead of time before you file your petition for your client in court. There have been cases where, for example, where I've interviewed the parent or the guardian and I've interviewed the child, and it turns out that there is something going on As far as the safety or within the relationship between parent and child or adult and child, such that it is not advisable at that particular time to go ahead and file that custody case. So you do want to make sure you have that information. You do want to make sure you review all of your information with the client before filing anything in court. A lot of this, you all, is lawyering 101, but I've been surprised, honestly, by seeing occasionally lawyers will file things and they won't have reviewed it with their clients, and then those cases will come back to us to pick up the pieces later. So make sure you review it with your client. Make sure you review it with your client in a language that they understand. If the client needs an interpreter, you must work with an interpreter. Usually it is strongly discouraged to use, for example, the child as an interpreter for the parent, or a family member as an interpreter, because of the sensitive nature of those relationships, and also because you want accurate information and you may not get it if you have an interested party acting as an interpreter. Finally, you want to discuss risks with family members before filing in state court. We have a lot of hope that this will generally be better overall under this administration, but especially under the previous administration, kind of anything a family might do to expose even a little bit of their immigration status to any authority could put them at further risk of immigration enforcement, right? So we would have to have that talk with the family members. For example, the child may be eligible for SIJS, and it's important for them to seek that benefit. But if the adult who has to go to state court is undocumented and perhaps has a prior removal order from immigration, that adult may not be willing to take the risk of exposing themselves in state court. In Chicago, we've been, to some extent, fortunate to be able to say it's not a policy to allow ICE into family courts. We haven't seen them go to pick up family members who filed those petitions. But again, it's not anything we can guarantee, and we do want to make sure that the families understand that that risk exists before filing. And again, we are hopeful under this new administration that the risk of sort of generalized enforcement by people accessing justice, accessing a state court for whatever type of case they may file, is significantly less at this point. So drafting your pleadings for state court. Okay, so depending on the type of case you file, that's what your pleadings will look like, right? We have a couple of samples that we're trying to make sure that we've appropriately modified so that they look generally like Indiana state court pleadings. But this is something that can be very venue specific too, right? The way that let's say, parentage case that's filed in Marion County is supposed to look maybe different than one in Elkhart, right? So you do want to make sure that you're filing the appropriate type of pleading for the appropriate type of case. If necessary, call the clerk to figure out what forms you need to file and when and how. I would say especially in times of COVID, some courts are fully remote and have e-filing, and some courts are not, and some judges are used to certain types of forms and motions. So you really want to know your judge and you want to know your courtroom as you're preparing just the format of your pleadings. Specific to SIJS, as you're preparing those pleadings, in addition to your regular counts, right, in your petition for custody or your petition to guardianship. So for example, you might say the child has resided with the petitioner for X amount of time. Petitioner is a fit and proper person to be appointed or to have sole custody of the child. You also want to then allege your facts that are sufficient to support a finding of that parental abuse or abandonment or neglect, and that it's not in the child's best interest to return to your home country. We've gone through a number of different ways of doing this, and what we've found to be most effective at this point has been a pleading that just incorporates those as facts that are alleged in a regular pleading. You are also welcome to allege it by separate motion. So you file your petition for custody or for guardianship, and then you file a separate motion asking for the SIJS findings. But I have been just including them as additional facts alleged in my regular pleadings, and that's been much more efficient and raised less questions at this point. So you would allege those facts. The parent has not been involved, child hasn't seen the parent since X date, or, you know, parent would regularly physically abuse the child doesn't have any other appropriate caretaker in their home country, etc. And then in your prayer for relief, you include that formal request for SIJS findings. So when you're asking for, you know, that your client be appointed primary custodian, etc., you're saying, and we're asking for a finding that the child cannot be reunified with this parent due to abuse or due to abandonment, and that the court find that it is not in the child's best interest to return to wherever it is that they're from. That being said, again, as I said during Lisa's part of the presentation, this is not an asylum case. And we want to make very clear to our state court judges as we're educating them about what SIJS is and what their authority is here, that we're not trying to make it an asylum case. So we don't need to tell an entire story of the child's journey to the United States, of other harm that the child may have suffered in great detail, etc. And particularly, we don't want to mention the parents, if we can avoid it, mention the parents or sponsors' involvements in the child's journey to the United States. This was a big fear of ours. Again, under the prior administration, parents were being punished for helping or facilitating their children escaping harmful situations and accused of smuggling or trafficking humans, right? So we want to try to leave that out, as it's not particularly relevant to a custody case, and it could end up being harmful to that parent or guardian in the future. But again, we want to keep these, as always, you want to keep your pleadings succinct, right? So include the facts sufficient, but you don't need to include every single fact. You'll find out at the final hearing what specifically the judge wants to hear more about. Questions, concerns?
Hey, Hillary, yeah, there's a question that came in that's asking, if the abusing parent is in the United States, how do we prove that it's not in the best interest of the child to be returned to the home country?
Well, does the child have anyone in the home country who can take care of them? Like, if the child is here, they're here for a reason, right? Did they come here with the abusive parent? And if the abusive parent is here, is the abusive parent going to take them back to the home country and like take care of them there? The not in best interest to return to home country is often connected to abuse the child may have experienced in the home country, but it doesn't have to be solely connected to that, right? So children may come here for a variety of reasons, right? Like a very common story is child was living with their abusive family member, their abusive parent in home country, and they fled that abuse and they came to the United States perhaps to live with their non-abusive parent, right? That's a very standard story, but it doesn't have to be that way. There's many children who, you know, came with both parents fleeing some other sort of violence or deprivation, but now they don't have anybody to take care of them. Or the child was living with a non-relative in home country and they started being, you know, threatened and attacked by gangs, and they came here to find their parent who had been living here for years, working and making money to send back to them. So there's a number of reasons that a child may not be in a good situation if they went back to their home country. Does that answer your question? I'm like looking through the questions on this side. Let's see. Oh, I see one about contents of pleadings. I'm sorry, Lisa, are you able to see these? Because they are like super minimized for me and I'm not able to read them fully. The contents of your pleadings. There we go.
Sure. I think the question on the contents of the pleadings is goes back to, I believe, when we were talking about those 3 Indiana Court of Appeals decisions. So would you affirmatively cite those cases in your pleadings to say, hey, judge, like, you should be comfortable with this? Or is that something where, like, maybe you keep them in your back pocket, and if you get to court and the judge is like, why on earth are you asking me to rule on an immigration case? You can say, there's precedent for this and support in Indiana law. So I think, yeah, strategically, where would you raise those, or how would you use those cases to your advantage?
Yeah, I would do the latter. And again, you know, I run the Illinois program and we've been doing things a certain way for a while that we found has worked for us. I would recommend my way because I came up with it as a way to start. But what I prefer to do and what's worked for our program is keeping those pleadings succinct, as I mentioned, alleging those facts sufficient to support your request, but not going into the detail of like what SIJS is in those pleadings. What we tend to send out to our pro bono attorneys as they're filing is a sample pleading that has the facts sufficient. That's a super short pleading and standard. And then if they get questions, or just as a matter of course, submitting a separate memorandum of law explaining what it is that we're looking for, right? And I would refer then back to the facts sufficient and the prayer for relief in the initial pleading, saying we requested these specific findings. Here's why. Here's SIJS. Here's our case law that supports it. Here are the citations to Indiana law that we're seeking these findings under. And here's why you, judge, have authority to enter these. And I would do that as a separate memo, just because that then allows me to lay out my argument in a way that's not getting confused by just the standard pleadings of like custody, you know, the client information, et cetera. But yes, we are looking to be sufficient to inform the judge, but not piss the judge off, right? The judges are our friends. We just they sometimes need a little bit more information to know that they have the authority to do this. And can you advance the slide one, please? All right, so here we are at the magic language. This exact language has to be in your final order. It is going to get tricky because sometimes the judge doesn't want to enter this exact language, or it doesn't match what, you know, a form order the judge may have is. But this language must be exact, because if it is not exactly this, USCIS will reject it because they are also very tied to the way their forms look. So what the exact language that we need is reunification with their parent is not viable, or reunification with their parents is not viable. You'll see that I have in here one or both parents. I'm sorry, it's confusing. It doesn't need to say one or both parents. It actually needs to say the name of the parent or the name of both parents. So that's the first absolutely necessary finding. Reunification not viable with ex-parent or ex-parents. And then the second is due to abuse as per IC, you know, 131, whatever it is that defines abuse under Indiana law, or due to neglect as defined by blah, 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 include your state court citation, or as to abandonment. You don't want to recite this whole due to abuse, abandonment, neglect, or similar basis. You want to pick the one that is applicable to your case. You want to include the specific citation that defines that term under Indiana law, and that must be in there. And then finally, there has to be a finding that it is not in the child's best interest to return to their home country. We've had some cases in the past where a judge has entered a finding that it is in the child's best interest to stay with their caretaker in Indiana. USCIS is not going to take that as sufficient either. They really want to see that it's specifically not in their best interest to return. Depending on what you are able to get, if you have sort of a back and forth with the judge about this language, please be in touch with your immigration attorney or with NIJC if it's a pro bono case, because we can kind of work with you to see, you know, what the best approximation we can get is and what's worth it to fight about here versus whether there's something that we may want to instead fight about at USCIS. But in general, what we're asking for is in your final judgment for custody or in your final guardianship order, in addition to placing the child under someone's custody, it has to include these three things or it will not be sufficient for SIJS. Questions about those findings? I'm trying to look up here again to see. I don't think so. Okay, can we advance the slide, please? So we've included for your convenience here the citations to these definitions under Indiana state law. These terms may be defined in other places. These are the ones that we've found to be most applicable here, right? Because they are defined in acts that govern custody and best interests of children. So abuse is defined in Chin's cases. I don't think that necessarily prevents you from referencing this abuse definition in a non-Chin's case, right? That is a place that it's defined, it's contemplated as to a particular purpose, right, in a Chin's case, but there are non-Chin's cases that involve abuse and you need to reference some sort of definition. So that's one that we can include here. Abandonment, almost every state has the UCCJA, right, or the UCCJA in the case of Indiana, that includes this same definition of abandonment as left without provision for reasonable and necessary care or supervision. That's like the most straightforward abandonment definition, and it's the one that's most common across all states. So we recommend using that if applicable. If not, there's a separate one in the Adoption Act. And then finally, there are neglect definitions in a number of different statutes. We would recommend using the CHINS or the family definition as opposed to the criminal definition, just because we don't want to confuse any aspect of this case by trying to say that it's a criminal case, right? But we do want to refer to some specific definitions as we're alleging those facts that we have that we're saying meets that definition. Questions about those? So again, these three types of harm are the ones that are sufficient for SIJS, right? Abuse, abandonment, or neglect. If you have a case where you think there's some other Indiana definition that could be classified as a similar basis under state law, let us know if it's an NIJC case, right? There is that other similar basis provision, but usually it's something that has to approximate one of these types of harms. So the way that we would frame it in both our initial pleadings and in our final judgment would be by saying respondent neglected or respondent abandoned the minor children by failing to perform these essential caretaking functions pursuant to whatever definition we're using of neglect or abandonment, in that she failed to provide food, shelter, economic support for the child for 8 years, had no relationship with the child, et cetera, et cetera. You want to have like 2 or 3 facts in there to support that. You want to have your definition. So again, these are the things to keep in mind as you're drafting those initial pleadings. You want to be descriptive enough to meet those definitions, but not so descriptive that you're creating like a 10-page, initial petition. You do want to give specific details about why, for example, it wouldn't be in the child's best interest to return to her home country. If you have one abusive parent there and you know that the child would have to return to that abusive parent, then your job is pretty straightforward. You re-reference that abuse and you say the child would be abused. If the parent's not there, or if you have an abandonment case, or if your situation is just a little bit different than any of these, you do want to think about those best interest factors that you may already be thinking about in like a regular custody or guardianship case. Like, would the child be able to access schooling? Would they have someone to care for their basic daily needs? Would they have access to health care, access to other necessary resources? Are they well adapted to where they're living now? Have there been threats of violence against the child? And again, we want to keep these specific to this individual child as opposed to trying to make generalizations about the country that they're coming from, unless that's related to this child's exact story, because we want to work really hard to try to avoid confusing this type of case with an asylum case, which it is not. Okay, so another thing we want to keep in mind as we're drafting the pleadings and as we're drafting that proposed final order is what USCIS is going to be looking for when they look at this final order. So if you remember from that initial SIJS statute from the INA, the final provision, in addition to the child being under 21 and married, having these findings, is that the Secretary of Homeland Security has to consent to the grant of SIJS. And that just means they approve the petition. But they do, USCIS does say they want to see that the SIJS request is bona fide. And it is a complicated sort of thing to allege, right? Because Congress created this form of relief and said, child, in order to access this form of relief, if you've been harmed, you have to go first to a state court and seek a custody order and seek these findings as part of this custody order. And now USCIS is sort of saying, but if we think that you've gone to this state court and sought these findings specifically in order to submit your petition, then your request is somehow fraudulent. Their position, I disagree with. I think it's weird. I think it's wrong. It's not really the purpose of SIJS. All that being said, we can frame our pleadings in a way that sort of helps us to make that argument. So we're focusing on the harm to the child. We're focusing on all of the reasons that a child ever needs a legal guardian or someone who is officially authorized to make decisions for them. as opposed to saying straight up in your pleadings, hey, judge, this child needs this order only for SIJS and for no other purpose. Mixed motives are okay, according to USCIS. So we usually have standard language in all of our pleadings that just says, like, child is here, they're a minor. If there's someone who needs to make an emergency medical decision, for example, other sorts of emergency decisions, it's going to be helpful to have this order granting custody to this adult in English. There are a number of reasons why that is useful and why it exists under state law to begin with. So focusing on that, rather than trying to explain the child actually has no need for this order except for the purposes of SIJS. Does that make sense? Are there questions about that? Looking again over in questions. Okay. Moving on. So again, we're re-emphasizing that we do want this final order to contain some evidence of the factual basis, right? So we have that magic language that must be in there. The magic language in and of itself is not going to be enough without one or two sentences explaining why the facts here support those conclusions. So what you see on the left here is basically just a parroting of the language from the INA, reunification with one or both parents not viable due to abuse, abandonment, or neglect. Like, that's not specific, that tells me nothing about the facts of this case. What we do want to say is child's reunification with father is not viable, he abandoned her, here's the Illinois definition that we're alleging, here are the facts that support that this meets that definition. And you can see that this is like 1.5-ish sentences. It's not a ton, but it's enough to say, hey, our facts meet this legal definition. So then finally, we have this provision. So our required language is reunification not viable with the parent due to abuse, abandonment, or neglect, whatever it is under state law. And the third provision is not in best interest to return to home country. So it might be helpful as you're drafting the pleadings or preparing for the final hearing or preparing your memorandum to explain the judge their authority, to review those best interest provisions again, right? The best interest standard is what is standard in determining custody of a child. So, you know, you want to look at the age of the child. What does the child want? How's the child adjusted to their life here? What is the, you know, what's their community like? And then what would all those things be like if they were forced to return to their home country? And if it's possible to say there's no appropriate caretaker in their home country, include that. That's appears to be a sentence that USCIS understands or meets one of their sort of templates that they're looking at, and usually is the case because the child is here. If it were in their best interest to be in their home country, if someone were taking care of them in their home country, they'd probably still be there. Okay, so as you are going through this process, you should be communicating with the immigration attorney. This is really important sort of from the very beginning, right? Because as Lisa said at the beginning, there are children who may be eligible for SIJS, but we may advise them, or maybe eligible for multiple forms of immigration relief, but we may advise them against it for some specific strategy reason, right? That has to do with the posture of their immigration case or what other things they may be eligible for. Or they may be applying for multiple forms of immigration relief at once, and we need to make sure that we are not submitting any conflicting information in any of those petitions. In addition, as I mentioned, depending on what you say in your pleadings, anything that you allege in this court case can then come into the immigration case and affect it. So communicating with the immigration attorney throughout the process of this state court pleading, of this state court process, I mean, is essential. In Illinois cases for the program that I run, we need to review both the pleadings and the final order before they're entered to make sure that the language is going to work, that it's going to be appropriate, and that it's not going to conflict with anything that we have ultimately submitted in the child's immigration case separately. In general lawyering tip, right? Always cross-check facts and content of documents. Just making sure that you're not submitting conflicting information to different bodies is a very important, just attention to detail lawyering tool. So that will be important in this case as well. Questions about that? All right, so you've drafted your pleadings, you've submitted your petition to court. The next step is service of process, right? If you have a custody case or if you have a guardianship case, it's notice to the parents and whichever other adults may be required by statute to be notified. I want to point out again here, SIJS cases are typically default cases. And that is because even in cases of really bad abuse by a parent, and I'm speaking from my experience in family courts in Illinois, it could be different in Indiana, but because we're asking the judge to enter a finding that reunification with a parent is not viable, if a parent is contesting custody and seeking visits, it is so unlikely, absent a Chin's case, basically, that a judge will enter a finding that reunification with a parent is not viable. Like even in the most, even when I did domestic violence work in Illinois, even in the very most abusive cases, usually the parent was going to get some kind of visits. They'd be supervised or they'd be something, even if they've been abusive to the child, right? It was rare the case where there were no visits, there was no possibility of reunification. That being said, we are not asking this judge to terminate parental rights, right? We are just saying, the judge is saying there can't be reunification, and by implication, there's not going to be visits. But when I screen, for example, my clients to see if they're SIJS eligible, if I see a kid in a situation where there's a potential custody battle that's going to come up, I will almost never find that child eligible for USCIS. For SIJS. I won't recommend that the child specifically go into state court and start that custody battle because it's not going to be fruitful. It's not going to get us what we want. So what does that have to do with service? What it means is service in these types of cases is typically via publication, because we don't know where the other parent is, or potentially via consent because the parent simply has tapped out. They don't care. They're going to sign off. That's fine. And occasionally there will be personal service, you know, whether the parent is here or in home country, we've been able to effectuate personal service in both cases. Questions about that? I know service is where people will sometimes get freaked out because we're talking about we're talking about different countries sometimes. I'm waiting to see if there are questions about service. So the most common service options that we use are personal service, right? That's pretty straightforward if the parent is in the state that your case is filed in, right? You file the case, the sheriff serves process on the individual, and then they have 30 days or whatever to file their appearance or be defaulted. Publication is also relatively straightforward. You file your motion saying, I don't know where this person is, can't determine where they are, we think they've left the state or they've never been in the state. The court then has to approve publication. You publish a notice in a paper for 3 weeks, after which the case can proceed without them. It's important to note, publication is meant to be constructive notice, not actual notice, right? I think the Indiana statute on publication is different, and correct me if I'm wrong. In Illinois, the publication statute just says publication in a paper in the county where the case was filed. That means if parent was if their last known whereabouts were in Honduras somewhere, the court is not going to order me to find a paper in Honduras to publish the notice because it doesn't matter, it's constructive notice. And the statute doesn't require it. I've seen a number of Indiana judges require publication in the paper in home country. If that's what your judge makes you do, that's what they make you do. But I would push for publication in the same country in the same county, honestly, where your case was filed, because we're not trying to actually notify the person typically. This provision is meant to allow relief, allow a case to go forward, despite the absence of the other party. But again, that's, I think, an Indiana specific quirk. Finally, let's say you know where the parent is and they don't care. They're willing to sign off. You know, they're like, my kid doesn't live with me. Yes, I haven't really been around. You know, even a parent who may have abused or neglected a child may be willing to sign off on a consent to custody to someone else, particularly if they understand that this means, you know, this doesn't mean they're going to get hit with a child support suit, probably, especially since we're finding that reunification is not viable. It may be one good thing that they're willing to do. If they understand this is something that will help their kid and doesn't take anything from them, We've had a number of abusive or neglectful parents sign off on these consents and waivers, and it's allowed us to go forward much more quickly and efficiently in these cases. So it's worth talking about. Talk about it with your client first, see if it's something they're comfortable with and if it's something that might work in your individual situation. Questions about that? Concerns? No? Okay, can you advance the slide, please? So finally, you're preparing for your final hearing. So let's say you filed your petition, you've perfected service of process, you've moved for default, or you've proceeded via consent. Your final hearing is where the judge is going to hear the testimony from your client, proving up those factual allegations that were included in your petition. As always, the most important thing is to know your judge. Know your judge, know your courtroom. Really, more importantly, know your judge's clerk. Call, check standing orders online, ask other practitioners in that area, right? None of us know all of the courtrooms and all of the places, but I think it's really important to just check ahead of time and figure out what exactly it is that your judge is going to want to see. Some courtrooms have very specific sets of forms that they need to be signed off on and filed and sent in ahead of time. Some courts are completely remote, some courts are not. That is something that you'll be responsible for finding out ahead of time and doing your research to understand before you proceed to a final hearing. You also want to make sure that you have prepared your client to testify. And I think this may be on the next slide, but I just want to make sure to go over this. If your client, meaning the petitioner, meaning the adult guardian of the child, is going to testify as to the contents of what you filed, you want to make sure you've asked them those questions ahead of time. Another just like basic lawyering thing, you never want to ask a question in court that you do not already know the answer to. So make sure you've asked your clients about, you know, the relationship with the child, how long the child's been living with them, to the extent that they are aware of the abuse or abandonment or neglect. You want to make sure you've gone over that with them. If there's information that only the child has, you want to make sure ahead of time too that it's okay that the child testifies. In many courtrooms that have to do with custody, judges don't like seeing kids in there. It's not particularly an appropriate environment for children, with some exceptions, right? If there's an older child, if the child has been asked to nominate their guardian, or if there's a GAL that's been appointed, those are situations where the child might be more involved. But what you typically want to focus on is making sure you have everything that you can get from your adult petitioner. The judge may ask questions as well, so prepare your client to answer those questions or to just be surprised perhaps. But if all goes well in that final hearing, the judge will enter your final judgment that you've drafted with your proposed SIJS findings. These instructions were really for pre-COVID times for in-person hearings, but you do want to make sure that if you're going in person that you have multiple copies, etc. So finally, we've included for your convenience on this slide some sample final language in that final judgment. So it says the minor's father has abandoned her within the meaning of Indiana Code 3121-2-2. In that he's provided no meaningful support, has had no involvement in her life, etc. That's the abandonment, that's the definition, those are the facts supporting. And then we've cited the Indiana Code for the best interest factors. So under Indiana Code 31-14-13-2, it's not in the best interest of the minor to return to her home country because of the abandonment, also because of the dangerous environment she experienced, and because there's no other appropriate caretaker. And finally, we're saying the minor's reunification with her father is not viable due to his abandonment. So those are the findings we want to include in every final order, appropriately edited for your factual situation. Any questions there? Concerns? I see one that says what to expect.
Yeah, Hillary, there are a number of questions about the immigration court removal proceeding component and adjustment. And I think maybe if we just wait until the end, and if we have time, we can address a little bit more on the immigration piece and the adjustment piece, and continue our focus now on the state court predicate order process.
Yeah, that sounds good. I apologize. I'm really not able to see these well enough. I should have figured out how to expand my screen ahead of time. But right now, yeah, we're talking about getting that predicate order in Indiana State Court. If we have time at the end, we can talk about adjustment and proceeding before the IJ. Okay, just quickly, one challenge that we've encountered is if, really and only if, the child's father's name is not on a birth certificate and we're making these allegations as to the father, that means that it's in the state court proceeding that we have to establish paternity. This is what USCIS says. They're not going to accept allegations against a guy who's not on the birth certificate unless paternity has been established in some other way. So what that means is you have to file a parentage case in Indiana, and you may encounter some jurisdictional issues there, right? If dad doesn't have minimum contacts with Indiana, if he's never been to Indiana, it may be challenging to get an Indiana judge to establish paternity, but not impossible. So if you have a case like this and it's a pro bono case, talk to us, because we do have some strategies. There are some jurisdictional bases that we can allege. We didn't go into them here because they're really in the weeds, but we have been able to do this before, and it really depends on your individual factual situation. That being said, if this is a dad who can be found and convinced to consent and acknowledge paternity, that might be best. If the father is unknown, or if, for example, mom was raped, and that's why dad's not on the birth certificate, talk to us about that too, because we think USCIS's position on this is kind of BS, and particularly in a situation like one of those, like if mom was raped and that's why dad has abandoned the child, like that is not mom's problem to then try to establish paternity, right? That is a classic case of abandonment. We should not be requiring that child to establish their paternity in order to obtain that child relief based on being harmed. If you could advance the slide. Okay, so other challenges include that non-viability finding, right? So as I think I have mentioned before, this is not the same thing as termination of parental rights, and we do want to make it very clear, because this isn't really language that comes up so often in regular old custody or guardianship cases, but it is very restrictive language. So again, these are uncontested cases. If you have a contested case, you know, good luck, bless you, but it'll be really much more difficult. You do want to just really make sure you know your facts ahead of time before you seek this language. Okay, and I think that is it from my end. And unfortunately, you all, I'm going to have to hop off, but feel free to email if there's specific questions that your other two lovely presenters are not able to answer. And thank you so much for attending this training.
Great. Thank you, Hillary. We really appreciate you walking through that whole process. It was very, very informative. All right, so for our last section, I'm just going to walk everyone through some of our tips for best practices, you know, when representing and representing individuals remotely, especially when we're working with sometimes minor children and those who are survivors of trauma. We're not going to spend a ton of time on this. There are a lot of questions that we still want to get to, so let me just hit a few key points. Okay, so first and foremost, we cannot emphasize enough the importance of using interpreters. The majority of our clients, almost all of them, in fact, of our clients who are currently seeking SIJS predicate orders are Spanish speakers. A lot of them, even more so, they might speak Spanish, you know, quite well, but it's actually not their first language. There may be a native, a speaker of some indigenous dialect in Guatemala or Mexico. And so we really want to always confirm what is the individual's best language, what they're going to understand, and, you know, understand the proceedings, ask questions best, and make sure that we make arrangements to have an interpreter for all communications if you do not in fact speak that language fluently. Oftentimes, you know, some people might say that, oh, well, they speak, even though they're an indigenous speaker, you know, their Spanish is pretty good, and, you know, my Spanish is pretty good, so we can get by. And in some cases, that's an assessment that you can definitely make. And if we're confident about that, sure, you can proceed. But I think even in those situations, we really want everyone to make sure they understand, fully participate in the preparation, that they understand all of the risks involved in any decisions being made, and really they just have all of the necessary information to navigate their case and make the right decisions. Also, NIJC, if you're working with us, we are not the ones who will be acting as interpreters or providing interpreters. That ends up being the pro bono attorney's responsibility. And we really don't ever want to ask the clients specifically to provide an interpreter. That can just be sometimes a logistical barrier or just an ongoing issue that we won't want to have to deal with. So we really just put that all on the pro bono attorney working the case. With working with interpreters, obviously there's some additional challenges that come into place. Everything is being said twice, so those meetings will take longer. You have to plan for that. I think it's also important to note that even though you're working with a third-party interpreter, you're still should be directing all of your questions and all of your responses to your client, rather than saying, can you please tell them this, or can you please ask them that, and either turning your body or not towards an interpreter. We really just want to make that connection. The interpreter is not so much a full participant in the conversation, but a resource to be used to aid the communication. The communication is happening directly between you and the individual that you're representing. Always reiterate any time that an interpreter is being used, or if a third party has to be present, that especially in this situation, that they are still bound by all of the same rules of confidentiality that apply when it's just the attorney and the client present. It's really important to stress that for clients who might have to discuss in detail prior abuse or neglect, and just make sure that they feel comfortable, that there's that atmosphere of trust, that they can share things with you, and it's not going to be shared back with maybe the guardian or the individual petitioning for guardianship, or with parents or other family members in the US or in home country. We just want to make sure that that is very, very clear at all times. And I guess just general tips about really making sure that you are speaking in a way that's going to make it easy for the interpreter to interpret what you're saying directly and concisely, and then also just simple, direct statements that the client will understand more easily. So, short sentences, plain language, no legalese, no terms of art, and make sure that you're pausing regularly every few sentences just to allow them to translate, and, take questions if needed, and then move on. Another thing, especially because we're all remote, and some of this might be very obvious to others who've done a lot of client work remotely over the past year, but we have to be flexible and really utilize a number of different communication tools. This, not only because there's so many that we can choose from these days, but there's also just some that are more convenient and more accommodating to our clients. We use WhatsApp and Facebook Messenger quite often with clients, just because it is, a service that will allow you to send text, photos, video, everything like that. And if that individual is connected to Wi-Fi, they don't need to have, a phone plan or a data plan in order to communicate. So that can be really, really useful for individuals who don't have, a full-on data plan or sufficient minutes to communicate. There's other things also. If you don't want to communicate directly with your personal cell phone, you can use things like Google Voice, which will connect your cell phone to your computer, or route it through another line, so that way your number will be masked, but you can still have direct communication. And also through all of this, I think with our clients, we always want to reiterate who we are, what is our role, provide again your name, your contact information, beginning and end, because like I sort of reviewed at the beginning, it's a very large and roundabout system that they sometimes find themselves in, navigating between government agencies, federal courts, sometimes multiple legal organizations or legal entities and support services. And lines, who is who can be a little confusing. Who works for the government, who doesn't, can be confusing. And again, we just really want it to be very clear in their head who is their attorney, who is their legal advocate, what does that mean, what is their role, and then being able to associate a face to that name and to that role. So to do all this, you really have to have clear plan from the beginning. I think always talking with those clients up front, getting all the contact information, establishing that they are safe ways to communicate. Some people are in situations where they can't freely communicate. They might be in some sort of, unfortunately, an abusive situation where calls or texts are being monitored. And obviously, if that's the situation, and you're working a case with NIJC, please let us know so we can take appropriate action in those situations. But confirming, how and when to best communicate with someone, and make sure that that is sort of a plan to regularly have check-ins. And then again, when you communicate at the beginning of a conversation, just checking in with them that they're in a safe and confidential place. If you're doing video chat or some sort of video communication, just pay attention to make sure are there any nonverbal cues that are indicating to you that they might not actually be in a safe situation, that they might not actually be in a private space, that they feel comfortable speaking freely about certain issues. All right, I'm gonna move past this one to just some of the last slides so we have some time here. Like I mentioned also, sometimes during the process you would be working with minors who have survived trauma, and all of these experiences that they're going to be accounting or recounting to you, these are human experiences, and some of them are very serious and traumatic incidences. So just take all of that into consideration and recognize that sometimes their memories are not going to be exact. Sometimes there are going to be some inconsistencies maybe in statements over time, and that sometimes they just might not be able to open up initially about some of those circumstances, even though they are essential to the legal case, even though they're the basis of the form of relief that everyone's seeking. Discussing violence can be really, really difficult. Family dynamics involved with these situations can be very complicated and can create a lot of hesitancy, both in guardians and in the children seeking protection. And then again, there are going to be individuals who are survivors of trauma, and that is a very there's definitely an additional set of skills and additional set of considerations that you have to have in order to really work in a way that is centered around that individual and protecting that individual and not re-traumatizing them through the legal work. So I think the most important thing is really preparation as far as a skill there, and putting more of that on you as the attorney. So that means if you have a series of questions or a set of information that you want to get, see if there are other ways that you can get it rather than directly from them. Can you review records, transcripts, filings, any sort of documents that you have that will give you some of that basic information? Can you speak to other individuals who have all the relevant knowledge? Do you have to go directly to that individual to talk to them through sometimes the answer is obviously going to be no, you have to talk to that person. But when you do, make sure that you are doing that in a way that's sensitive to the topics and the history there. So short meetings are great. I think kind of limit the scope and provide them with some choice throughout, so that way they have some agency in the situation. They have some control of the situation, whether or not they feel comfortable and ready to speak about certain topics at a given time. Anytime you're asking about more difficult topics or more sensitive topics, providing context and an explanation for why you need that information, how it's going to be used, what and how you can assure them it will not be used or who it will not be shared with. And then just keeping things kind of, short and concise, and like I said before, not always expecting complete consistency for throughout those interviews. And then lastly, we have to, I think, remember also that right now, very extraordinary times, all the circumstances around COVID that affect everybody in a number of different ways, but financially, economically, emotionally, sometimes it just might really reprioritize or change the individual's priorities, and that's because if those immediate needs are not being met, if we have a family unit that is food insecure, housing insecure, worried about work or where their next paycheck is going to come from, they just might not have a whole lot of focus and attention on the questions you're asking, and those immediate needs are more important in that time, and we have to recognize that and accept that, and work with clients to meet them where they're at in order to make sure that they can navigate those important priorities and needs, and then we can still have some understanding about when we can move forward with the legal case. All right. So I'm going to wrap there, and we can move into questions. I know that there's some already in the chat. Let's see. Lisa, do you?
There are a few, and maybe I know that as we're approaching the end of the hour, there are going to be some of you that will need to drop off and move on to other things. So Ellen, if you are on and can pop on and talk people through the evaluation, and if there's anything further they need to do to obtain their all-important CLE credit, which we want to make sure you get, maybe you can provide some guidance on that, and then we can shift back to questions.
Perfect. Thank you. Wes, Lisa, and Hillary, great job. And hello, Indiana. We're so excited to see you here, and thanks for showing up. What a great way to spend a frigid, snowy afternoon. And so we hope that you enjoyed this presentation and that you, are invigorated by some of the changes that we can push forward in SIJS law in Indiana and protect, these kids that really, really need it. So we are super excited to be working with Kids Voices in Indiana, and for Lindsay and for Julie for your help with this. You know what? We would like to hear your feedback about what you thought of today's presentation, and any other questions, please shoot in the chat right now. But for your feedback for the presentation, there is a QR code that you're seeing on your screen right now. If you hold up your device, it should pick it up and you can answer like the 4 or 5 questions in a minute or 2. Let me just say that evaluations are necessary for CLEs, so this is a great time to do it. Otherwise, there's a link to the evaluation that's there, and we'll send it out in a follow-up email with the materials and the PowerPoint slide. As Wes mentioned at the beginning, this presentation is being recorded, and so we'll also send out a link to that evaluation. Lisa mentioned some of the most important words of this presentation. Besides SIJS and immigrant children and be a good attorney, there's also CLEs involved, right? If you're interested in CLEs and you didn't put your bar number in at the time of registration, I would ask you to please send it to me ASAP or within 3 business days so that we can get you that CLE credit. We will send you in the email, the follow-up email, my email address so that you can get that into us, and a certificate will also be sent at that time. And finally, before we get to the last questions, just 2 more quick points. If you liked what you saw today and you're interested in getting involved, there is a case list, and we have over 50 cases in need of representation, individuals and families, and many of those are in Indiana. So I know that Wes and Lisa would love your support there. And if you're interested in other types of matters, and or more CLEs that are free in Indiana, next week we're talking about U visas. And so our team, Trisha Teafilo Olave and Liz Beth Sanchez, will be speaking about U visas and how you can get involved in that too. Free CLEs, same procedure. So we hope to see you there. So thanks again for joining us. My name is Ellen Miller. I'm the Pro Bono Manager, and we look forward to engaging with you. I'll turn it back to Lisa and Wes to answer all of your super important questions. Thanks.
Thanks, Ellen. I think the questions that I'm seeing actually move us a little bit out of the SIJ, the predicate order phase of the SIJ case into immigration court. So we'll talk about that a little bit, recognizing that really what we're talking about today is the process in the state court, getting that step one, that predicate order, which we see as so often being the stumbling block and the obstacle that prevents children from accessing SIJ protection. So again, our hope is that you leave this meeting here today feeling more confident, more equipped to go into state court and take on some of those matters. And if you want to do that in partnership with us, you'll have Ellen's contact information. Our email addresses are all up on the screen there. Reach out to us. We're eager to partner with people and figure out how we can do a better job of serving immigrant children in Indiana, many of whom probably qualify for this relief, but aren't able to access it because they're not able to get that predicate order component taken care of. So keep that top of mind. The question is a few technical things. One was, what happens if you're representing a child now in the immigration court proceeding and they referenced a fear of return, so maybe kind of signal that they would be seeking for asylum when they originally arrived in the United States but are now seeking SIJ. And I think generally that's very unlikely to prejudice a case. A child, certainly shouldn't be expected to be able to articulate, oh, I'm pretty sure that I'm eligible for the certain visa that I've heard of. And the fact that the child has articulated a fear of return and is subsequently applied for another form of relief, I think is unlikely to come up in immigration court, unlikely to be something that a government attorney would cross-examine a child about in court. And so I think probably will not be problematic. And again, this is all stuff that's happening in the immigration court proceeding, and if the child is in deportation proceedings, which many unaccompanied minors are, but a lot of the children that we're encountering that are in need of these predicate orders may not be in removal proceedings. They may have come to the United States undetected, or they may have come on a different sort of visa, fallen out of status, and subsequently been in need of this form of protection. So that's in the immigration court piece. The other question is, well, what if you're at this adjustment stage and you're going into immigration court? Hold on, let me refine the question here. Can you adjust before USCIS? So jurisdictionally, when the child is if the child is in deportation proceedings, jurisdiction over the adjustment is going to rest with the immigration judge, but it's very common for us to go into immigration court and say, hey, we've got this approved SIJ petition, so we've done the predicate order in state court, we've gone to USCIS, USCIS has approved our SIJ petition, then now moving on towards this adjustment, our priority date is hopefully current or close to current. Then we might ask an immigration judge to terminate removal proceedings and proceed before the agency to adjust. Again, we're getting into some really technical immigration law stuff that's a little bit beyond the scope of this training, but that would be one way to approach that situation. So Wes, are you seeing other questions pop up in our chat?
It seems
covered everything.
It seems like that's all.
Yeah, I think that's everything, aside from maybe a question about the link, being emailed the link to the evaluation. So I think that will also be included because we will be emailing around the slides at the end if the QR is not working. Ellen?
That is right. Yep. Eval link and the certificate and all the materials will be in a follow-up email.
All right.
All right. I am notorious for going overtime, and we are 1 minute under. So we are very proud to get you out of here on time. And hopefully you're enjoying, at least up here in Goshen, we have a little bit of sunshine, which is uncommon in our part of the state this time of year. So hopefully you're able to enjoy the rest of your afternoon, and absolutely do reach out to us. If you want to partner with us on a case, or if you're handling a case on your own and need to tap into, some other experience on that, reach out to us as well. Let's all work together and hopefully collectively increase access to SIJ in Indiana. So thank you all so much. Have a great afternoon.
Bye, everyone. Thank you.